What I want to talk about today is it's a work in progress, like a pre-work in progress, if that makes sense. Paper I'm hoping to write, but it builds on two papers from a while ago, and so I'm going to kind of introduce the theories that my co-author, who I guess was here a few weeks ago, Anthony Niblett, and I put forward in earlier papers, and then where I think that leads us for arbitration. And so anyway, so the next phase of AI in arbitration, or the self-driving contracts in arbitration, and the self-driving contracts part is the work we've done before, and we had kind of, way 7 years ago talked about what it would look like when we have kind of the technology we have now that would take what we call self-driving contracts and turn them into a new form of arbitration. And that's where I really want to go, but I'll kind of put the building blocks of our former papers. And so you'll notice the slides, they change in style here, Nick. So there's the older paper and the newer paper, kind of merge them together, but you'll get a sense of what's from 7 to 10 years ago and what's new. So our very first project looking at the effect of artificial intelligence on law was, we started writing in 2014. And people really told us we were dreaming about science fiction. And I think when ChatGPT kind of exploded in the popular mind, it started to look like the things we talked about actually are happening. And so we had this idea of what we called a micro directive. And we wrote about it first in public law and then in private law. And so the public law version is simply, what if technology could predict what the law should be? And that could mean a lot of different things, and I'll come back to that. But let's just say it's a perfect predictor of what you want to accomplish, and it can gather data in real time. And so then it could give you law that changes and updates to the perfect context of your situation in real time. And so we thought about, you have this prediction technology, and what does the law look like? And so you might have a rule that existed before that said you should drive no more than 60 kilometers per hour. You might have a standard that says you should drive reasonably, and you're kind of left with these two choices. This is the rules and standards choice. And our first paper was actually called The Death of Rules and Standards, because what we said was technology is going to make it that you don't have to choose anymore. And the reason why there's a choice is if you say 60 kilometers per hour, everyone knows what they're supposed to do, but sometimes it's not the right thing to do. If it's a perfectly sunny day and no one else is on the road, you're driving and you're like, I wish I could be going 80 because it's totally safe. But if it's pouring rain and there's ice on the road and there's animals, then you're like, it says 60, but I'm not comfortable driving more than 40. And if it says drive reasonably, then you're supposed to incorporate those factors into your behavior. But what if you get it wrong? The law might punish you even though you thought you were doing the right thing. So that's the choice, and the legislators have to make the choice. And that's the kind of rules standards idea. Now, the truth is that when you apply a standard after the fact, you say, well, what was your situation? Well, you were a 32-year-old, you have 12 years of driving experience, you were driving this type of car, a rainy street, you should have been going a certain number. And you're like, yeah, well, no one told me that. The micro directive is the idea that, well, we can get all the data about the situation and predict what you should be doing in that situation. It comes up on your dashboard and it tells you, this is what you do right now. And, again, people are like, oh, like that, could that ever happen? You think, like, it actually does happen. That's how self-driving cars themselves work. They have to decide what the right thing to do is in the moment. And you could also imagine, well, take out one step and say, well, tell you what to do. And so the micro directive is the law that is stated as a goal, and then it gives you this momentary instruction, like, do this now. We have this, we want to be efficient, and so you do this. We want to be welfare enhancing, we want to redistribute wealth in a certain way. You set the goal, and then the law can change to it. And we use the speed example because it was the most kind of salient, but our theory was all of law could start going this way. And if you think of stop signs and yield signs, I don't know if they have, in the US, it's a stop sign is you have to stop. A yield sign is stop if you need to. And a stoplight that has sensors is the micro directive version. It's like, go now, don't go. All right, so that's the public law version. That's what we were writing about in 2014 and 2015. And then we said, well, what about private law? What if I used the same idea to write a contract. And this was a paper we wrote in 2017 that we titled Self-Driving Contracts. And just kind of step back and say, you know, what is the theory of contract law that we're dealing with? And so the economics of contract law talks about there are complete contracts, which is a theoretically perfectly complete contract that covers everything in our relationship that might come up. And then there are incomplete contracts. And so a very incomplete contract it has all kinds of gaps and it doesn't tell you what to do in certain situations. And there's no truly perfectly complete contract. And it's just a matter of how incomplete you are. And you can put standards in contracts to try to make them more complete ex post, such that the judge says, you know, did you behave reasonably? That's what the contract doesn't say. You have to buy this many goods. It says you have to buy a reasonable amount of goods. All right. And so you can think of, you have an incomplete contract, a contingency comes up, and then it wasn't set out specifically in the contract, and the court or the arbitrator, we'll come back to later, decides how to fill that gap. That's the idea of incomplete contracts. Courts have to decide, do I fill gaps or do I just say, whatever the status quo is, when you come to litigate, there's a gap, we don't do anything. And so in a world where you have an incomplete contract, you're putting in the content at the end of the day. After you find out what the contingency was, then the court or arbitrator says, here's the content, right? If you have a complete contract, you would have the contract content in the contract. So if this happens, you do this, there's no question about it. The contingency is set forth in the contract. You wait till it happens and then you perform. And the court doesn't have to decide anything other than, did the contingency happen and did you perform? All right, so what we theorize is, and this was in 2017, that as technology gets better at predicting the things that might happen and the way that those things will affect our relationship, you'll get more complete contracts. So there's going to be future states of the world that we didn't realize were going to come up before that we now are able to predict and put into the contract. Another way you could think about it is, it's really costly to write all the terms into a contract, but less so with technology. And so, you know, if you remember when COVID came around, there were a lot of contracts that didn't have anything in them about pandemics. Now, some people said, oh, it wasn't foreseen. And I actually did a project with Anthony Nibba on this, where we looked back in the US in 1917, there were all kinds of contracts that were disrupted by polio outbreaks. And the key ones that were litigated were what was called beautiful baby contests. And so a local county would have a beautiful baby contest, and the regulators would say, well, not when there's a polio epidemic, because that's really a bad way. That's a way to get the babies all sick. And so then what do you do with the contracts? And so it wasn't unforeseeable that this would happen. The law had dealt with it 100 years earlier. So why didn't contracts have it in there? Well, because it's a very low probability event. And it's costly to think about not only what could happen, how does it affect each of us, and then how do we want to resolve that risk ex ante. But if you have technology, you can say, you know, if I use a predictive algorithm and you use one, I know what I would want to do in certain things. What is, you know, the probability of, what are events with probability over 1%, and you kind of put it all in the contract. And so those contracts will account for more and more possibilities. And so the first step in that would be the contracts would get longer. But then we point out that the next step is that they would get shorter. And the reason they would get shorter is, well, what if instead of saying we're going to put in the contract all of those things that we predict, we say, well, I don't, if I put it in there, I have to read it. Why don't we just say, what is our objective? And then when the contingency arises, ask the algorithm what it would have done if we'd asked it ex ante to put in the term, and then do that. And we commit to doing that ex ante, even though we don't know what it is, if we trust the predictive algorithm. And so then we say we'll see contracts where parties agree on an objective rather than a specific term. And this is the same thing in the first slide, the micro directive. The public law could say, I want to maximize efficiency of driving, but also minimize traffic jams. And I set levers of how efficient, how fast I want to be, how many accidents I'm willing to tolerate, and then I get what the reasonable speed limit is. In the contract, you could say, we want to maximize our joint welfare, and we want to allocate risk 60-40 or certain different ways. And then we agree that whatever the thing is that we're using, ChatGPT or whatever, can tell us what to do when the contingency arises. So we want to maximize surplus and split it a certain way. And machine-driven algorithms could provide that. And so we were, again, this is in 2017, and we were saying, what if the law got to the point where it could do that? And so what would happen is you would have ex ante commitment to terms that are unknown. And so in the previous slides, it was incomplete content at the end or complete content at the beginning. And here it's complete content at the end. So you and I have agreed to what's going to be the way we're going to resolve the question in the future, but we don't know the answer yet because we don't know the question. But we've agreed to say we commit to that happening. And so we then compared this to self-driving cars and said, it's kind of like you say, oh, like I want to get from A to B. I choose the destination. The car is going to determine the best route. The parties select their objective. The contract is going to determine the provisions to get there. And that's why we use that analogy. And so the idea, again, is the contingencies arise as the circumstances arise that give you the contingency, and then it tells you what to do. So the one thing that ties this to arbitration is this is a lot of how people resolve contract disputes with incomplete contracts and arbitration. We don't agree that we're going to let a contingency be resolved by an algorithm, but we basically do when we say, if a dispute arises about whether something is reasonable or not, or this particular thing, we will hire an arbitrator from these potential firms, and they'll tell us what to do. Well, that's just an algorithm, but it's not it's harder to predict, but maybe we're like, oh, they have a good track record. We will arbitrate this dispute, and we agree to arbitration later down the road. And so we started saying, well, this looks a lot like arbitration, but it's not a human doing it, it's the algorithm doing it. And I'm committing to it. And so at one point we said it's kind of like, and we didn't love this term, but it was like ex ante arbitration, which is kind of a oxymoron. It's like, wait, like how do you arbitrate? But you're like, I agree to the outcome that this arbitrator, this algorithm will give me ex ante, and it's going to tell me what it is ex post. And we talked about how there are examples of this already. Again, this is in 2017. And so pricing, people agree to contracts that don't have set prices all the time. And as technology advances, the setting of those prices could be through an arbitrator, or it could be through sensors and technology. So in an auto insurance contract, the way they do in the US is they say, here's your rate. You put a sensor in your car and the rate will go down. Now, they do that because the law has a weird thing about, oh, if the rate went up, that'd be bad, but if the rate goes down, that's good. But it gets you to the same place of, if you're a bad driver, you pay this. If you're a good driver, you pay that. And the sensors are put in your car, and it finds out information about you, and it sets the price based on that. And the data is interesting. They say that the most important two things in car insurance pricing when they use the sensors are whether you drive at 2 a.m. on a Saturday, and that tells you whether you're going to get in an accident on Tuesday. But that, if you first start wait, and you're like, oh yeah, like the kind of person who's driving at 2 a.m. on a Saturday is more likely to be younger, a little more reckless, a partier, and they're more likely to get in an accident even on a Tuesday. And then how many times you hit the brake in like a minute, and that's like you're tailgating people, you're driving too fast. Home insurance, you can have things in your house that have sensors that tell the company what to charge you. Dental insurance, they even have brushes that are fitted with sensors. So price terms can be determined that way. You can also determine, which technology determines whether what counts as non-performance. So the law says you have to have a reasonable notice period under Canadian employment law. And what is reasonable depends on a lot of factors, but now there's technology to say, here's what a court would say is reasonable. And so you could have a contract that updates and says, not just reasonable, you need to do this is the set period for this relationship. Oh, it changed because a new court opinion came out, or it changed because something about your relationship changed. And that technology exists already. It's just a matter of can you automate it and have the contract update. And then we talked about how, again, this is in 2017, we're about natural language processing and compliance. So you say, am I complying with the regulation? And we read, we feed data of cases into the large language model. And we say, well, what is compliance currently? And if it changes, if the law says, oh, non-competes are no longer allowed, the contract changes. You can't do a non-compete anymore. And it flags this for you. And it's like putting up in front of you things to do. Non-competes being the example of that. All right. Then we said, well, what about substantive performance? So the technology exists where you have algorithms which tell you which clauses you should use to achieve certain outcomes. And that this technology has been advancing and say, I want a provision that does X, here's the provision. But if you turn it around and you could say, well, I have a provision that says this, what is that? What do courts say that means I have to do? And so you just say, again, what's our objective? What's the thing I should be doing? And those technologies can be brought together to do this, to create this self-driving contract technology. All right, so I said earlier, it's a lot like arbitration where you're saying, all right, arbitration is incomplete contract contingency, fill gaps. And you just say, I agree to the arbitration ex ante, and it makes things complete in a sense. It's complete in the sense of there's nothing for us to do later. There's no judge involved. It's just the algorithm will spit out something for us to do. And that's the same as the self-driving contract. And so then we predicted that the technology of self-driving contracts has a lot of things that it has to get right. So you have to have the right person writing the algorithm who's trusted by both sides. You have to have data that is available, but it might be confidential data, so you wouldn't necessarily be available to everybody. The company processing the data might want to keep it proprietary. And so you need to have a trusted intermediary when you want to write a contract. The insurance examples I set up, they're not really symmetrical relationships. So it wouldn't surprise me if the insurance companies manipulate these things to make sure it benefits them because they're a big player and you're just signing up and saying, oh, I want a discount. But when you have two sophisticated parties, they'll have a different view. They'll say, well, I want to have a relationship where we do this, but I don't trust you or your data provider. And so who's the likely intermediary to come into that space? Well, arbitrators, because they already are doing this ex post. They're trusted intermediaries who have data on their own decisions, who regularly look at data from judicial decisions, who are collecting data about contracts and those sorts of things, and could even do more of that if it brought in more work. And they could say, look, one thing you can trust us for is to keep your data confidential, but give it to us so that we can now, you give us your data, you give us your data, and we can regulate your relationship for you. And that's where this kind of next step is like, okay, so is this happening? And now post the boom of LLMs, what are we seeing in the world? And does this lead to a change in the way cases are arbitrated and a change in the way contracts are written? And so in 2017, we said, with the self-driving contracts, parties can agree to broad objectives and let automated analytics fill in the specifics based on real-time contingencies. So that was us 8 years ago. And then a year ago, Arbel and Hoffman have a paper on generative contracts. And they basically said, we've done this, we're there. We finally arrived in this world. So we were saying we could do this. And they're saying now that we're here, why wouldn't parties simply write out jointly held goals, those are the objectives, at the beginning of the relationship, and let the model spit out the codes of conduct and legal responsibility as problems rise down the line. That's exactly what we were predicting. And I love their paper because it says, look, it's here now. And they run a bunch of tests and they say, oh, if we have this contract term, how would it be interpreted? If we have this one, how would it be interpreted? And then their point is, what's the next step? Skip writing the term and just say, I want to end up in a certain place. And then I just agree to that. And then we say, well, what would the term look like about this particular situation when the situation arises? So that's the kind of predicted point. And just to show a few examples of why we're here now, like, so, the point of the paper that I'm working on writing is that we're here now, and let's see how it's playing out. Last year, a judge in the 11th Circuit just writes this, he's writing an opinion, he's trying to interpret statute, and he says, the whole case turns on what physically restrained means. And the judge goes, I couldn't help myself, so I asked ChatGPT. And so he just puts into ChatGPT, and the opinion lays out the various things he got. And in a footnote, he goes, I asked it three or four times, and it gives slightly different answers. And I really like the way the judge does it, because he's like, but that's probably, the first people are like, oh, look, it's giving different answers. But imagine if you ask 3 experts, and they all basically have the same view of the world, they would give you 3 slightly different answers. Imagine if you ask the same expert 3 times, but not in the same sitting, like one day, next day, the next day, but you didn't let them take notes. They'd probably give you the same answer with different words. And that's what he got. But so he says, look, I'm trying to find out what the ordinary meaning of something is. And I have this data and this program that's built on all of the language data out there. And so why don't I ask it what the ordinary meaning of these words are? Now, there are, he does this in passing and he doesn't base his decision on this. And then there are flaws in it, because you have to think about, okay, so did he know that he have the settings on ChatGPT right? Did he ask it ordinary meaning in the jurisdiction that we're in? Did he ask it ordinary meaning when the statute was written? And there's I don't even know the legal answer to that question. I don't think anyone does. Like, when I say ordinary meaning of a statute passed in 1967, do I take the ordinary meaning today? The theory would be the people reading the statute should understand it. Or do I take the ordinary meaning in 1967, what we want to get the intent of Congress? He doesn't go there. He doesn't play with that problem. And those are where the law has to grapple in the future. But he just shows you that you could do this. And again, you could do it for public law. You could do it for private law, and you could do it for arbitration as well. And so one way to think about the self-driving or self-arbitrating contract is you have a large language model, and I've done this with recipes. It's really good at certain things. Like people were saying, we were talking about this at the conference I was at. It's really good at like travel itineraries. It's really good at like, how do I cook this or that? You just put this in. So let's say I want to accomplish a task: build a car, bake a cake, structure a loan. And I asked the large language model how to do that. It'll give me something. Now, then I put a condition on it. I say, well, I want to do it cheaply, efficiently. I want to have the best tasting cake. I want to have the best looking cake. I want to have it to be the state of the art car. I want it to be a profit maximizing loan. But you can ask that, and it will give you an answer. Now, I'm going to come back. Again, there are qualifications. You have to understand what the technology is. But what does he say? You could ask that question every day that you had to do this. And then they'll think about it. The parties, instead of writing a contract, could say, we want to bake cakes. We want to make cars. We want to structure loans. And we will agree to follow the instructions using this large language model provided by this data provider, this arbitration firm, whatever, what have you. And that's the agreement we come to. And that's the ex-ante arbitration, self-driving contract idea that we were talking about 8 years ago that we now think is here. All right, so now, like, that was the newer stuff. And now, like, just thinking about arbitration. So I did a panel a few weeks ago with a bunch of arbitrators, and this was just on how is AI changing arbitration. And I have a few slides at the end, about side topics if we get there, because we were talking about, oh, like IP law, is it, changing? Is arbitration better for it? Is it worse for it? And the arbitrators had a lot of thoughts on this. But it was very interesting to kind of play out where the world is. And so one thing they said is that as things in the world have gotten more complicated, arbitration is becoming more popular among sophisticated parties. Now, why is that? Because judges are generalists and arbitrators can be specialists, or they can engage specialists in ways that at least formal judicial procedure makes difficult. So a court can always have its own experts, but they're reluctant to do it. And it just, like, if you ever talk to a a sitting judge, they're more conservative about what they can do because they're worried about reversal, they're worried about the rules of procedure. Arbitrators, usually you agree that they can do the things within certain parameters and it can be more innovative. And so they could use the technology to bring in subject matter expertise to understand things that are novel or new. And so they can supplement that expertise, or you can hire an arbitrator with special expertise. And again, when you look at copyright litigation and arbitration today, about the New York Times is suing ChatGPT, those questions are really complicated and new. If you don't understand the technology, you won't understand the law either. And so that's where expertise comes in. And procedural flexibility is what allows that. And you can have AI assisted procedures. You can be as an arbitrator. And I guess I was in a conference in Europe last week, and a Dutch professor was telling me, I said the following, I go, everything in the court is open to the public. He goes, not in the Netherlands. I was like, oh, the US view of privacy is just pretty much it doesn't exist. And if you sue someone, it's all out there, and getting confidentiality is a risky thing in a court. He was saying it's not true everywhere, but certainly in the US, you got a lot more privacy and confidentiality when you arbitrate. When you litigate, the default is everything is public if it goes before the court, and you got to ask for special confidentiality rules, and that can be challenged even after you've gotten the agreement to redact the document. But arbitration is different. So that's a reason why, in a world where there's more technology and trade secrets become more important because a lot of it is not patentable and copyright laws kind of in a weird space, you want to have confidentiality, and that makes arbitration more popular. And again, this was members from the AAA were on this panel I was talking with, and they were just talking about like they're predicting a boom in arbitration. All right, so you have that flexibility. You can use experts. You can actually have multiple experts from each side, individual. You can have human experts. You can have data AI assisted expertise, and this all changes the way parties arbitrate. And so that got me thinking back to our old paper that we might be in a world now where we have AI assisted arbitration and AI assisted contracting, and they start to merge again, because you say, well, why do I need to write the contract? If I know that I'm going to arbitrate it, I can just set out some basic goals. Now you have to think about the details. So do you need a human in the loop? Almost certainly right now you do, right? A year ago, people were really worried about hallucinations in briefs when lawyers were submitting them because they used a large language model and they didn't check it and they didn't understand that it was just predicting what word might look good in that place rather than looking at cases. But now, a year later, that problem, if you use Westlaw's AI, or there was a presentation at the conference this week by Harvey, they've solved those problems. That particular one, we probably still need a human reviewing things. You need to understand what the technology is doing. This one struck me, especially in the last month or two, when there was the release of the DeepSeek to compete with ChatGPT. And people are like, look, it can explain its reasoning. It gives you this narrative of how it came to the answer. And people who understand technology are like, that's not how it came to the answer. That's just it predicting the words that would look right in explaining how it came to its answer. Now, that might be exactly what judges do too, right? Like we always say, like, what is a legal opinion? Is that really why? When in the US, the conservative justices say the text says this. This was at the bankruptcy conference, my presentation. I was like, that's what they said. That is not the truth. They didn't like bankruptcy courts in the particular example. So they fit the text to mean what they wanted it to mean, but they said the text meant this. Same thing with the large language model. You don't know that that's how it got there. So you have to understand what you're reading and what you're predicting. You're predicting what someone would say in this instance, what someone might do. You're not doing the I want the most efficient thing unless you trust that its data was constructed to get it to that outcome. And that gets you to the data you use and data you train on is super important to all this. And who contains that, processes that, holds it for you. That's where arbitration has a huge advantage, because a court is not going to be able to promise to keep the data that you're using or training on confidential, and it won't have It'll have publicly available data, but you might be like, oh, we really need to look at this private data or bring in some sort of additional supplement. So those things have to be kind of on your radar when you're thinking about self-driving contracts or arbitration this way. So again, it's predicting how things would be written, not necessarily, or how it has to be accomplished, not necessarily how to achieve your particular goal. You have to understand what you're getting. It's a technology that is really formed on mimicking. And we had talked about this in our early papers. You might mimic judges, or you might try to do what they're doing better if you know what your objective is. Now, one problem in law and in contracting is sometimes no one's in agreement on the objective. And so the legislature, 5 Congress people might vote for one reason, 5 might for another reason. So there's all kinds of objectives. And so you might say, well, we don't know the objective. We just want to mimic what courts are doing or what people have done in the past. But you need to understand what you're doing in these particular contexts. Other considerations. So I think, I don't know how many of you were here. I know that Anthony Nibbett was here a few weeks ago. This relates to the work I think he presented. You have to understand how AI judging and AI lawyering interact with each other. And, at every conference I've been at, the lawyers are one step ahead of the judges, but the judges are learning and using the technology. And so if you predict an outcome of a case as a lawyer, that will affect the settlement of the case, and kind of wonky things happen depending on your assumptions. And Anthony and I have a paper about settlement, and we've got all these charts of like what it might look like if certain technology is available to certain parties. And I think his new paper is taking that even one step further. But it's really complicated to think about how my access to predictions affects my settlement behavior. And then if I know you have access to predictions, that changes that behavior even more. And then right? And that's a game theory problem. And then if we know the judge is using the technology, it gets even harder, because now I'm not asking, if I'm a lawyer, what was the judge likely to do before? I'm asking, what is the judge likely to do now that the judge is using the predictive algorithm, which it creates cliffs. So the way we talk about it, it's like if judges are 60% likely to do this, but all the judges use the technology that tell them that, then they become 100% likely to do it. And if I know that, then my settlement offer changes. If I'm the one who's 100% winning, I'm not offering anything. And so you have to understand how that plays into things. And there will be what we talk about as an AI arms race, right? The lawyers are trying to get ahead of the other lawyers and ahead of the courts. And this really could throw off litigation, but then arbitration may be able to prevent that or even harness it if they're the lead cutting edge and their technology is a little ahead of the lawyers or the courts, or they find a way to constrain what the lawyers can do, and they can be, again, more innovative. So it might be a way to protect against that problem. So the main point of all this is that we're likely sitting at this point of a merger between contracting and arbitration that really gets us where we have been talking. And just a few examples. So this is not my slide. At the bottom, I put, it was from Svetlana Gitman, who's at the AAA. But on the panel we were on, she was showing me that they're using Clause Builder to write not the contracts that are arbitrated, but the arbitration contracts. So you go in and you say, what is the clause that I should use? And they've got this product out there to write the contract, the arbitration contract for you. And again, it's only one step further to say to write the underlying contract for you. And then one step further to say, just sign up to have us resolve your disputes and don't worry about a contract. This was one of her other slides where she talked about how they're using ClearBrief and other AI-powered tools to assist arbitrators way ahead of what judges are doing, right? Just judges are, as I've heard it, as basically in the US at least, they'll put a brief into AI and ask it to, ask Acrobat to summarize it for them. So they're using it, but it's not really what we're talking about in these other instances. So the lessons of all this is just like we need to think about who's going to draft or arbitrate the contract, and how do we want to regulate third-party providers? Because in the sophisticated situation, great, the market works. In that insurance consumer, it might not work, right? You need to think about whether or not this gives the big player more power. Think about what data is available, what data can be used, how people can keep it private, what the incentives are there, and how privacy plays into all of this. Again, my sense is the U.S. has a very different view of privacy than most other jurisdictions, but it really is something to think about. And in all of this, you have to know what it is you are doing when you state an objective about law or contract. You have to know what you want to do. And what we like, Anthony and I like, is that this kind of forces people to think about what they're doing, why they're doing the contract, why you're writing the law. Because a lot of times it's just like, oh yeah, let's agree to this. And if you're using the kind of AI-assisted arbitration or contracting, you have to be like, why am I doing that? What's my goal here? Am I just doing it because my lawyer's like, oh, we always ask for this in this relationship? That might be the reason to do it, but it might not be. And so you want to think about the goal and the objective going forward. So I know I've used a lot of time, so I should stop there and open it up to questions.